Good morning, sir. This is Kurika here to present today's given topic, types of contract. So, before proceeding toward what are the types of contract, we should know what is contract. So, here it is written contract is the simplest definition of promise enforceable by law. The promise may be to do something or refrain from doing something. The making of a contract requires the mutual assent of two or more persons, one of them ordinarily making an offer and another accepting it. So basically, contract is an agreement or promise which is enforceable by law made between two or more parties. Next, we are proceeding towards the main topic of this presentation, types of contract. So in this chat, we are observing that it is divided into three heads. Each head classify many kinds of contract. First is mode of formation, which is classified into four kinds. Performance, which is classified into five kinds. Validity or enforceability, which is classified into six kinds. So let's discuss about each and every kinds of contract. First head is mode of formation. Under this, first point is express contract. Here it is written an express contract is a contract whose term the parties have explicitly set out. This is also termed as special contract. In an express contract, all the terms would be specifically stated. In an express contract, the agreement of parties is expressed in word either in oral or written form. So, express contract is an agreement exchange. Express contract is an exchange of promise, which is in which party agreed to be bound and declare either in written form or orally or in combination of both. For example, where a landlord present A with a pre-printed lease on an apartment that A wants, if he agreed to the terms and sign it, then it is an express written contract. Another example is I offer to sell you my 1987 Mercedes, and after some negotiation, you agree to purchase it on the terms we have worked out. A bargain for less than $10,000. This is an express oral contract. Now we should proceed towards the next topic, implied contract. Implied contract is a legal binding obligation that derive from action, conduct, and circumstances of one or more parties in an agreement. It has the same legal force as an express contract, which is a contract that voluntarily entered into and agreed to verbally or written by two or more parties. So basically, kind of contract which creates legal binding obligation between the parties. The contract is not based on any written or oral agreement. For example, a patient walk into a doctor office and receive treatment. The patient's action shows that he or she intend to get treatment from by the doctor, and the doctor welcoming the patient and perform of the service shows that he agreed to render the service. Here we have an implied contract even though the patient and the doctor did not formally exchange the words of agreement. Next example is you contact a web developer and ask them to maintain your help design a web for you. Not only they design your website, but also they give you web hosting service even though you had not asked for it. With regard to the web hosting service, they resend you an invoice for rupees 2000 per month and you paid. This goes for a year. After a year, you refuse to pay the service they render, claiming there was no contract between you. So, in this example, we have an implied contract of web hosting service. They had offer you the service from one over a year, and you keep paying the monthly fees. And if you're not paying it, then it can be considered as a breach of contract. So next point is quasi contract. Here it is written a quasi contract is retroactive agreement between two parties who have no previous obligation to one another. It is created by a judge to correct a circumstances in which one party acquires something at the expense of the other. It means a quasi contract is a functional contract recognized by a court. So, there are some example. First example is a person orders some permissible item online by providing his address and paid for the same. At the same time of the delivery of the goods, the delivery man deliver it to the wrong address. The receiving party then, instead of denying the delivery, accept the order and consume the same. The case went to the court, and court then ordered the issue of quasi contract, according to which the recipient has to pay back the contract cost of the item to the party who's the person who paid for the item initially. So in this case, the benefit of the goods have been enjoyed by the receiving party. So such receiving party is bound to give an compensation to former parties. Another example is A leave his wristwatch at B's house by mistake. Here B has quasi contract obligation to return it to A. Now proceeding towards next contract, E contract. E-contract is a kind of contract formed in the course of e-commerce by interaction of two or more individuals using electronic means such as email. The interaction of individual with an electronic agent such as computer program, or interaction of at least two electronic agents that are programmed to recognize the existence of the contract. So e-contract are not paper-based contract; they are electronic in nature, and in this contract are generally made for speedy entering into the contract. There are some example. First example is an agreement or a contract is sent through email, and the example is customer drawing money from the ATM machine. Another next head is performance. Under this first point is executed contract. Here it is written, an executed contract is a legal document that has been signed off by the people necessarily for it to become effective. The contract is often made between two or more people, but it can also be between a person and an entity or two or more entities. So, a contract under which unperformed obligation remain on both sides, or where the both parties continuing obligation to perform, this is called as executed contract. For example, a contract in which the promise are made and complete immediately, like in the purchase of a product or service. Another example is a contract between a painter and homeowner, whereby the painter agreed to paint the exterior of the home owner's resident in exchange of homeowners paying rupees 10,000 after the painters paints the home, and after homeowners paying 10,000 rupees, the contract is fully executed as opposed to executory. Next point is executory contract. An executory contract is a contract made by two parties in which the terms are said to be fulfilled at a later date. The contract stipulated that both sides still have duties to perform between perform before become full executed. The contract is offered in place between a debtor or borrower or another parties. So basically, it is a contract that has not fully performed. For example, an apartment lease. When you enter into a lease agreement, you are performing to pay the rent for the period of time. Another example is sell his car to B, rupees 2 lakh. If A still to deliver the car and B yet to pay the price, it is an executory contract. So next point is partly executed and partially executory contract. It is a contract where one party of the contract has fulfilled his obligation and another party has still to perform his obligation. So it is a contract where one of the party has already fulfilled his promise and another party yet to perform his promise. For example, X offered to sell his car to Y for rupees 1 lakh on a credit of 1 month. Y accept X offer. X sells the car to Y. Here the contract is executed to X, executed to Y. Another example is Anju and sell his bike to Vivek. Though Anju has delivered the bike, Vivek has yet to pay the price. So here the Anju, it is an executory contract. It is an executory for Vivek as price has yet to be paid. So let's proceed to our next point, unilateral contract. A unilateral contract is a contract agreement in which an offeror promises to pay after the occurrence of a specified act. In general, unilateral contracts are most often used when offeror has an open request in which they are willing to pay a specific act. So unilateral contract is known as discuss about the partially executory and executed contract. Um, the promise is outstanding in the part of both the parties. Example: Anju promised to pay rupees 1000 to anyone who finds his lost cell phone. B finds and return it to Anju. From the time B found the cell phone, the contract came into existence. Now Anju has to perform his promise, that is the payment of rupees 1000. So this kind of contract is known as unilateral contract. Next is bilateral contract. A bilateral contract is a contract in which both parties exchange promise to perform. One party's promise serves as consideration for the promise of the other. As a result, each party has an obligator on the party's own promise and an obligee on the other promise. In this contract, one where the obligation and promise is outstanding on the part of both the parties is also known as two-sided contract. For example, A promised to sell his car to B for rupees 1 lakh and agreed to deliver the car on the recipient of the payment by the end of the week. The contract is bilateral as both the parties have exchanged a promise to be performed within a stipulated time. Another head is valid or enforceability. Under this first point comes the valid contract. The valid contract is an agreement which is bind and enforceable. In a valid contract, all the parties are legally bound to perform the contracts. The Indian Contract Act 1872 defines and listed the essential of valid contract. Though interpretation through valid judgment, various judgment of the Indian judiciary. Basically, it is a contract entered into the parties and satisfy the elements of the valid contract. As per the act, it is said to be valid contract. For example, you sign to buy a blue house, and the house is blue. Thus, the contract is valid. Another point is void contract. A void contract is a contract that isn't legally enforceable starting from the time it was created. While both a void and voidable contract are null, a void contract cannot be rectified. In a legal sense, a void contract is treated as if it was never created and become unenforceable in court. So the contract which is meant to be enforceable by the law, it became void contract. For example, X offer to marry Y. Y accept X offer. Later, Y dies. The contracts were valid at the time of formation but, but become void at the death of Y. Next example is Mr. A agreed to write a book with the publisher. After a few days, A dies in an accident. Here, the contract becomes void due to impossibility of performance of the contract. Next is voidable contract. According to Section 2I of the Indian Contract Act 1872, agreement which is enforceable by law of the option of one or more of the parties thereon by but one or the option of the other or the other is voidable contract. In other words, voidable contract is one which can be set aside or avoid at the option of aggrieved party until the contract is set aside by the aggrieved party. It remains as a valid contract. So it defined that an agreement which is enforceable by law at the option of one or more parties but not at the option of other parties. Contract can be voidable in case like undue influence or fraud or misrepresentation. For example, agreement in which the party is still in minor. Contract involving fraud, deceit, or other forms of trickery, or contracts made when one party was drunk, incapable, or not to legal sound mind to form a contract. Next example is a contract made by the minor is offered voidable, but a minor can only avoid a contract during his or her minority status and for a reasonable time after he reached the age of majority. After a reasonable period of time, the contract is deemed to be rectified and cannot be avoided. Next point is illegal agreement. Um, An illegal agreement is one of the object of which unlawful such as agreement cannot be enforced by law. Thus, illegal agreements are always void ab intro, that is, void from the very beginning. So, it is not enforceable by a court of law because it is purpose of the agreement is to achieve illegal end. There are some examples. First example is X agrees to Y rupees 1 lakh. Y kills Z. Y kills and claim rupees 1 lakh. Y cannot recover from X because the agreement between X and Y is illegal and also its object is unlawful. Another example is contract when opposed to public policy, immoral are illegal. Similarly, contracts to commit a crime like supari contracts are illegal contracts. Next is unenforceable contracts. An unenforceable contract is or transaction is one that is valid but one the court will not enforce. Unenforceable usually used to contraction of to void and voidable. If party perform the agreement, it will be valid, but the court will not compel them if they do not. So basically, it is a type of contract which satisfy all the requirement of the contract but has technically defect. It is called as unenforceable contract. For example, a contract for selling drugs or weed against law. And next another example is an agree to sell to rupees B. A agrees to sell rupees B. A agreed to sell B 10 kg of rice for rupees 10,000, but there are a huge flood in the state and all the rice crop were destroyed. Now the contract is unenforceable and cannot be enforced against other parties. another point is certain contract in written. Here it is written most of the contract can be written, either written or oral, and still be legal and force, but some agreement must be in written in order to binding. However, oral contract are very difficult to enforce because there are no clear record of offer, consideration and acceptance. So written contract actually shows that what are the party agreed to. So that there are some contract which should be in a written form. For example, contract for the sale of the transfer of an interest in land, and the contract that cannot be performed within 1 year of the making. In other words, a long term contract like a mortgage. So this type of contract should be in a written form. That's all. Thank you.